But for the record, Megan Gilmore on behalf of the respondent moving party, namely Dennis Iverson. This is before the court on my client's motion relating to where the children will go to school for the 2025-2026 school year, as well as the request for the court to review child support. First, looking to education, the children were previously attending the school district where my client was located. The children remained in this school district even after the parties broke up, as my client was the parent to take the children to their daily activities and appointments. My client purchased a home in Ridgefield School District in March, and he asked the court to maintain the children in his school district as historical throughout this case. My client has a permanent home in Ridgefield where he plans to stay for, frankly, the rest of his life at this point. Mother has temporary housing above a convenience store where she works, and no permanency in her current location. As bore out by the evidence submitted within our materials, Ridgefield is a far superior school district to Battleground. The research really shows and speaks for itself. The Battleground is well below the expectations. It's contrary to the evidence of Ridgefield, that's the number 2 in Clark County at large. Mother attempted, when going to extracurriculars, Mother attempted to paint my client as a bad guy in light of the extracurricular activities. She went as far as filing a motion to alternate the decision-making regarding extracurriculars. My client explains in his declaration that even after going as far as filing a motion, she was late in signing the children up for basketball last year. She then subsequently signed them up for wrestling, didn't take them for 5 weeks straight, refused them to allow them to participate in matches and tournaments. What I think is important and why I bring this up is, again, it's looking to who has historically been more of the primary parent in the case, and that's where the court should lean, or where we're requesting the court to lean when making a decision regarding the school district. Ridgefield will provide permanency, stability, what the children really need. They'll be able to transition with their step siblings that they will reside with and currently reside with, my client's current wife. So we do ask the court to grant our motion, allow the children to be enrolled in Ridgefield. That decision needs to be happening today. I understand the court is hopefully going to be making a ruling today. Today is the last day, based on my understanding, for both Ridgefield and Battleground, unless the children will be late starting. Turning to child support. Again, the parties exercised a 50-50 parenting plan here. The court did enter a temporary child support order in December of 2024. I was not an attorney in the case at that point, but I do believe that there was a lot more questions than answers relating to mother's income. At this point, we did bring the issue back before the court because we've received substantial new evidence that is different than the positions that she presented at the time of her motion last year. What the information we have is, based on her 2023 K1, she made over $40,000 in self-employment earnings. If you divide that by 12 months, that gives her a monthly income of $3,338. If you look at her 2024 K1, she had earnings of $42,880. If you divide that by 12 months, that gives her a monthly income of $3,567. Pursuant to RCW 26-19-071, all income outside of that specifically excluded within subsection 4 should be included. I make the analogy within my client's declaration that this is similar to BAH. I understand it's not BAH, but it'd be an identical argument that Mr. Zandy would be making in the event that my client was receiving housing benefits through the military. The case law is very clear. Income for housing benefits should be included for the purposes of the worksheets, and we're asking the court to do so today. Based on the information contained within our motion, we believe mother's housing benefits are no less than $4,000 a month. She acknowledged within her own financial declaration, her work is paying for her rent, her utilities, her gas. We believe far beyond that. More concerning, and I think what's even more necessitated the need for this motion, was the fact of the income available to mother at the time that she presented that she was impoverished to the court. Again, in December of 2024, she had over $51,000 in her personal accounts. She had $70,000 in a business account. She alleges that she doesn't actually have access to this, but I asked the court to really look at the statements of themselves. There's personal expense after personal expense after personal expense. She clearly has a very large fund of money that she can use to support herself. This information is vital when the court's deciding on a deviation for a residential credit. Under the statute, the court is going to be looking at if both parents can support the children and their needs. I think just looking at mother's financial declaration and loan, she sets forth that she has household expenses of $1,149. Within her own financial declaration from 2024, she's acknowledging that she doesn't have a need even before she disclosed that she had $51,000 in 2 bank accounts. So we asked the court to really reconsider the court relating to mother's income, as well as particularly the residential credit. Looking to my client's income, my client has provided the court an updated pay stub. The federal government recently reduced my client's pay based on his position. We provided the court the August 15, 2025 pay stub that shows that per paycheck, my client's income went from $2,022 to $1,796. My client also explains to the court the mother attempts to double dip within her declaration, where she is including both disability and National Guard pay. My client explains that you can't get paid for both at the same time. Therefore, when he's in active duty status, he then owes that back to the government. We provided under seal that he owes over $18,000 as of March of 2024 back to disability because of his active duty status. Therefore, this substantially reduces his income. I think it's also important to acknowledge that at the time that we were last before the court, a mother was arguing in November that my client's net income was $7,654, which is, I think, by $2 identical to what we're asking the court to find today. My client testifies to you that he doesn't have rental income. The rent that he may receive at some point only covers the mortgage, and he testifies to the court that he didn't receive it for June and July. There's simply, again, no alternative stream of income. There was also some question within the declarations regarding my client's costs for the children's health insurance. We explain the section in the pay statement that shows that he pays $657.82 for the children alone. He explains that his health insurance is covered by disability, so that amount is just for the children and should be included on the worksheets. We do ask the court grant our motion, allow the children to be enrolled at Ridgefield, order a zero transfer payment of child support commencing the day the court previously made the order, because we believe that mother brought her motion in bad faith without presenting all of the evidence, material facts that were relevant to not only her income status, but particularly relating to a deviation under a 50-50 parenting plan. My is really boring out a lot of these costs here by having these children, frankly, more than 50% of the time, given the amount that he participates in their everyday life. We do ask the court to deny mother's requests for fees. There's no standing for attorney's fees in a committed intimate relation case. I don't think statutorily there's standings for fees in a parenting case, absent bad faith, and this issue needed to be before the court regardless because the parties can't agree about school. Thank you.
Let me just ask one question. Ms. Gilmore, remind me again, where were the kids in school last year?
Woodland, where my client lived.
Woodland. Okay, thank you. Mr. Zandy.
Thank you, Your Honor. I think the court's aware I do represent a non-moving party, Janelle Anderson. I think we need to kind of backtrack here a little bit. I've got some preliminary objections that, again, I didn't want to interrupt Ms. Gilmore, but I do want these on the record. I would submit first and foremost that the information related to the school in one section of the declaration states it's common knowledge, everybody knows that Ridgefield is a better school district than Battleground. That's news to me. I had never heard that before. There was nothing to substantiate that in the initial motion, although Mr. Iverson was clearly the moving party. Didn't receive that until SIR reply. That's first and foremost. Second of all, there's information related to audits and things that my client has very, I think, intuitive and well-reasoned responses to that, again, we didn't get a chance to answer. So I would just ask the court, I know Your Honor is typically aware of that, to disregard anything that was brought new to the SIR reply as we didn't get a chance to respond to that. I'm going to stick my comments based exclusively on what I believe is properly before the court. And again, I've got more issues related to that. I was taking notes in counsel's argument. I looked back when we first received the motion, and I can say and affirm that this is largely probably within 80 to 85% the exact same arguments you heard last winter, and by my count, about 6.5 months ago, from the time my client filed. Absolutely nothing has changed. I went back and looked at our response. Now I looked at the K-1 schedules, the tax returns, the bank statements, the information from accounting, and it is largely the exact same stuff that you considered back in December. So I would certainly submit, counsel did state in her comments, reconsider. She's asking the court to reconsider its ruling in December, and I would submit that that should have been done within 10 days of the order being submitted 6 short months ago. So I think that's a jumping off point. There's been nothing changed outside of Ms. Gilmore is now Mr. Iverson, by my count, fourth attorney, and as the court's aware. Simply switching attorneys and choosing a new voice is not grounds to come back and reconsider when that ruling was never asked to be reconsidered or modified prior to that. With that said, I think the information again is pretty clear. It's not complicated. My client works at a mom and pop grocery store and lives above the residence. That's the same thing you heard last winter. It's the same way it is now. Nothing has changed. Her income hasn't changed. We've updated the 2024 information, and you see that she's within a couple $1,000s. I think her current net income of $22,346 is up about $1,500 from where it was in 2023. There's absolutely no change. If this sounds familiar, it's because you've heard it before. You've also heard the arguments related to this online venture that Mr. Iverson just will not let go, in which he's attributing $4,000 a month in income to her for selling basically secondhand clothes that the kids have outgrown. She sells, and she tells you, I think it was dresser or doorknobs for $15 in, I believe it was June. That was her only sale. She doesn't make any money off this. This is literally just trying to repurpose items so that she can make $1, so that she can buy new stuff, new clothes for her kids. Again, because as she tells you now for the second or third time, she's pretty financially conscious about that and savings conscious, and she has to be. So to submit that she's making $4,000 a month when there's absolutely nothing outside of just a generic, well, here's some pictures of the stuff she may be selling. Again, I think that's disingenuous to say the least, and that's something that you've already ruled upon. So that is kind of where it's at. As far as living above the grocery store, yeah, she does. That's one of the benefits, absolutely. That would equate to, as we've commented prior, to about $900 per month if that was to be rented out or she was to pay for that. That's a perk of the job. We've readily stated that from the onset. Everybody's aware of that. Your Honor considered that back in December when you put her income a little bit higher. Her income in the worksheets that exist is about $2,100 and change per month. You factored that in setting that income to her. You also said that there really wasn't any way to know what she was making, but you certainly didn't think it was much by way of doorknobs and kid recycled or, jeans that have been essentially outgrown by the children. There's no money in that. And again, it's reeks of desperation. And I think this kind of gets to the heart of Mr. Iverson, and that's where he's been from the onset of, I'm not going to pay. I don't want to pay. And I'll keep coming back time and again, making the same arguments to do that, as we're now having the same argument 6 short months later. And to Ms. Gilmore's credit, I realized she wasn't there, but this is, again, very familiar when I believe it was Ms. Petrie or Ms. Dow appeared on his behalf back in December. If we look at the information, and you've got the records for the taxes, there is nothing difficult to decipher when it comes and relates to that. The information by way of K-1 schedule, tax returns is pretty straightforward. Again, because this is a mom and pop shop, you can't look at in any business the gross receipts that a company makes. I mean, that's pretty fundamental. But Mr. Iverson is trying and attempting to do that for the second time this year. He says, well, you take the gross receipts and you divide that by 4, as there's 4 partners of this, there's 4 owners, and you divide that. We know that's not how it works. We have the information that specifically states that, and we've given you the information that shows on the K-1 schedule from the Hyson store what the total income for the store was. We've given you my client's personal tax return, which shows what her income is. We've given you information from the accountant, which confirms that. All the lines match up. All the dots are connected. And again, we're here yet again having the same argument and same debate. I can go into this for an extended period of time. I don't think it's necessary, as I am asking you to find that we've done this and there was no motion to reconsider. Nothing has changed. And as I kind of anticipate will happen, if you need further explanation, I'm happy to give it. But by purposes of income, it is what it is. To suggest that she has these accounts, I want to briefly mention those. So counsel is claiming that, well, she has these other funds available. She does. sort of in the same way that anybody else saves money in a savings account, sort of as anybody else has the luxury of a 401k or an IRA. There's funds available, but that's not income. Income is what they receive on a month-to-month basis that you can bank on, that's coming through the bank account or through the registry. And storing money over this period of time is not income, any more than a savings account to Mr. Iverson is income, or a 401k retirement to him, or a pension to him is income. That's just not what it is. It's an asset. So my client details for you, and I think it's interesting if you look at the Columbia Credit Union. That's the one with $35,000 in it. If you look at that, you'll see that my client's father is a co-signer on that. He's a co-signer because this account was opened when she was about 10 or 11 years old, and he co-signed on it for her as a child. And that's literally 30 plus years of birthday money, tax returns, that's graduation money. It's those types of things that she's just built upon. I believe that's the account also that child support currently since the first of the year goes in. So again, to look at that is kind of erroneous. Anymore to look at the fact that Mr. Iverson now has 2 different homes. He has a vehicle. He's purchased a Harley. That's not income, but again, that shows that he has income available to him. So we're talking about apples and oranges in that comparison. Same thing with the IQ Credit Union. Again, that's a small account, acts as a savings. And then finally, the account that is associated, I believe it's the Riverview account with the store, that doesn't belong to my client. She's on that account as a 1/4% owner. If you look at the statement, it shows that they're buying stuff for Frito-Lay, that's checks, it's payrolls going out of that. It's operating in the exact same capacity as any business fund would. And there's not a large amount of money in there. There's not a pot that they get to all take a dividend of $50,000 at the end of the year. That would be income. But to suggest that the money from the store that goes into that and then buys the supplies and restocks the shelves is some kind of income to my client, and although there's no proof, because it's not how it happens, that my client can't take it, again, is to suggest that that's some form of income to her, which clearly it's not. I mean, that would be fraudulent. We'll talk just very briefly about this. Mr. again in his reply, and I understand the court has read it, and it's difficult to unring that bell. So I did want to mention this. Talks about this audit that my client had 10 plus years ago. She says that's absolutely not true. That wasn't an audit for her. That was a simple IRS audit. At the time that they had the store run, it was on the store, had nothing to do with her. It was simple. It was resolved, and then the case was over. So again, we get all these red herrings from Mr. We get him kind of grasping at straws to try to present to you some kind of information that he finds meaningful to hang your hat on. And there's just not. It's the exact same stuff that we've already contemplated, that you already heard 7 months ago. Interestingly, and this is where I'm again always kind of concerned, this is the case where you had set the child support issues to be heard by a date certain last year. You gave each party a date certain to submit their materials. Mr. Iverson, to the best of my recollection, didn't do that timely. We were forced to kind of to pick and choose what was there. He gave us what he wanted to show us, gave the court the same thing. I believe the matter got set over a couple of weeks, gave him another chance, and we started getting stuff trickling in. That was the reality of it. We still didn't get everything. We still have the same thing going today. And I'm going to talk about his budget in a moment, because that is absolutely appalling to me. But if you look at just apples to apples, his income, he is getting a VA disability benefit. He's getting $2,460 a month. I don't believe that's taxed. He is getting money, although less, $594 per month from the National Guard. And he's getting $56.36 in civilian wages through his employer. That doesn't count. I'm interested when he says, well, I'm not getting any rents for the house in Woodland, suggesting that he could and he will. But right now in this moment, he's conveniently filed this motion and says, I'm not currently getting rents in this. This is a home in downtown Woodland by the schools. It's a big home. It's a spacious home. This is one that could go for $2,000 at least a month, probably more likely up to $3,000 per month in rent. We get no information about what he's got by way of renters that are lined up. We have no information from him about what his plan is for that. We don't have any listings from him. He just says, well, I'm not currently getting rents for that. Even if you plug in $2,500 per month to him that he's getting in rents, that's still income. It's going to be taxed as such on his returns, regardless of the fact if he has a mortgage on that or not. That is income, and I think that's how that qualifies for the IRS standards. So if you put that all together, the only thing that's changed since December is he's got this rental access of about $2,500 per month that he's going to have access to. That's going to bump his overall monthly budget income to north of $10,000, about $10,600 per month, according to what my calculations look to be. That doesn't account for any other household income with his wife or girlfriend or whatever she is. Doesn't account for that. Doesn't account for anything else that he might be making on the side. But the only change in circumstance we have right now is his income has actually gone up. Hers has stayed the same. In fact, it's still less than what the court imputed her at the 2135 last year. So that's that's the point on the income. So we are asking that be considered. Again, this is unfortunately somewhat par for the course on what we've dealt with since last fall when we started trying to address the child support pursuant to the court's issued orders. And we just keep getting the same time and time again, despite the change in counsels that happen about every 6 months or so with him. So we are asking you to deny their request to modify the child support. This is a case in which he's living very well. Look at what he's recently purchased. He's got a new home in Ridgefield. He still maintains the one in Woodland. He's got a new Harley Davidson. He's got a new Yukon. He's got a lot of new purchases. Yet he's the one who claims poverty. My client has never claimed poverty. She says she does the most with what she gets, and that's what she's doing, and that's what the information all indicates. So that's kind of where it's at. Jumping forward, and again, I think if we look at some of these other matters and we look at the school situation. Now, the school situation, I would completely disagree with counsel, and I wasn't involved at the onset of this case either. But simple review of the file shows that I believe it was Commissioner Carmi some time ago indicated that, well, if dad's going to stay in the Woodland School District, that's where the kids are going. We'll just keep them there for now, pending a GAL review and recommendation. My client made it known from the onset that she was going to live in the apartment above the store in Battleground. She's commuted since that time, and we now leap forward to currently the spring of 2025. Dad says, well, I've gone out and I purchased this home in Ridgefield. I want the kids to go to my school district. We've got various concerns with that. One of the concerns is we have really zero information, again, until the SIR reply, which was extremely late to provide, information about Ridgefield. I would disagree with counsel. I don't think it's common knowledge to know what school is better than the other one, especially in these circumstances in another county. But what we know is my client has roots in Battleground. She's lived in Battleground. These kids, pursuant to your order last fall, participate in sports in Battleground. They've done well. They've got an older sibling who goes to Battleground who can help acclimate them with things and make them a little bit more comfortable. There's a lot of benefits to Battleground. Battleground is just as close to school. It's a relative equal drive between my client's residence from the store and Mr. Iverson's residence in Ridgefield. It's very close. It's about, my client says, 5 to 7 minutes for both of them. It's within earshot. Contrary to that, he wants to uproot the kids, put them in, again, his district, not because it's best for the kids, but because it's best for him and because it also allows him to take some of that control back from her. If you look back at the court's very specific findings, so this was a case where they were pretty egregious. The court has found that he has taken advantage of that and abused some of those. Specifically in the November 19 order, it states, in part, the sole decision-making as to extracurricular activities is being abused by the father. The court went on to find that the language regarding telephone calls is being abused by the father. This is the same individual who would have the kids, my client would pick the kids up and he would call them on their way back to Battleground knowing that they were with their mom and insist on talking to them the whole way. That you found was abusive. This is the same thing. So now he's saying, well, okay, upset about that court ruling where the kids now get to participate in Battleground. So how do I take that back? How do I take some of that control back? Well, I'm just going to move and I'm going to put the kids in the school district of my choice that's most convenient for me. That's unfortunately what this continues to evolve in, and that's exactly why the court made those findings. If we look at the information that we provided, we don't really get a response to the information that shows Battleground is a perfectly suitable district. Battleground does very well statewide. Battleground is not this hole of a location that Mr. Iverson is trying to make you believe. I think if anything is common knowledge, that would be it. This is an area that continues to expand. This is an area that's rural Clark County, but by all intents and purposes, just as good as Ridgefield is. So we are asking you, due to the benefits of being equal for both parents, the fact that the kids have already been exposed to Battleground in some regard related to extracurricular activities, that the court order that the kids attend school there. And I can submit that I believe, now my client had indicated that back to school or meet the teacher night is tonight. So I would concur with Ms. Gilmore that getting some kind of direction on that is very important. If we look, and again, I didn't comment on this, I went in a different direction, but back to what has been submitted by way of the information that was exceptionally late, including Mr. Iverson's budget. I do ask the court to look closely at that. If you look at his expenses, he's claiming total expenses per month of $15,801. Included in that, he's got $7,187 of housing expenses. That makes up of some kind of a contract or mortgage he has in addition to other mortgage payments. I don't know why those are parceled out, but $7,200 almost in housing expenses. He's got for kids expenses $2,750. He's claiming that he's paying $1,250 per month for babysitting. My client would tell you, if this wasn't presented on SIR reply, that's absolutely grossly inaccurate. That is not an expense. He's got personal expenses. He says he buys himself $300 per month in clothes. He says he's paying $300 per month to get his hair cut. He says he's paying $150 per month for recreation and $50 a month on magazines. He's got $800 on personal expenses for his clothes, his hair, and his entertainment. That doesn't count some of these other things. He says school lunches of $200. My client says, yeah, no. And he's claiming to you, while not claiming any rent, that he's also paying health insurance, not covered by insurance for the kids, of $1,100 per month. This guy's ex-military. He's got a civilian job that provides insurance. He claims to be paying $700 per month for the kids in one spot. It's now apparently $900 per month. We've got no information to document that or substantiate that. So he's telling you that he's paying $15,800 per month in monthly expenses, but then telling you, on the other hand, oh, by the way, I only make $7,000 net per month. Again, this is the type of nonsense we've been kind of dealing with since last fall. This is what the frustrating part is to me, and I can certainly understand my client. And then we get dragged back in here to re-argue a case that has literally already been heard and issues that have already been determined. I would disagree with counsel. Certainly we can ask for attorney's fees and costs when we've been, again, pulled back into a situation where the issue has already been decided. Again, the fact that no motion to reconsider was ever filed, no review or second look at that was ever filed until he hires a new attorney, I think is dispositive of what the concern is. We are asking for $2,500 in fees and costs. Also ask that that be paid within a date certain. If he can afford $15,000 per month on fun stuff like Harley Davidsons and Yukons and house payments and magazine subscriptions and haircuts, certainly he can contribute to my client's fees. We do believe that that is appropriate. And again, I think that is kind of part of the issue we have with how this case is unfortunately processed. Important thing for my client is the kids. We do want what's best for them. My client absolutely believes it's best that they go to school in the Battleground district. I don't know where the assumption that Battleground is not her home and it's transitory and she's going to move comes from. That's not the case. That's been her home outside of living with Mr. Iverson when they were a couple for an extended period of time in Woodland. That's our request. And again, I ask the court to consider anything only in the initial motion, nothing that was provided by exhibits or new information in the SIR reply.
Did you have something in regard to extracurricular activities that was brought up? So I don't know.
No, I think at this point, if the kids are going, I think it depends what we do with the schools. The kids currently, it's a split. It's back and forth between Battleground and Woodland. I don't know that it makes sense for them to go to participate in Woodland activities. Although he purchased a house in the spring, and we were in court just a couple months before that, we didn't know, at least from what I recall, we didn't hear any mention that he was planning on moving to Ridgefield. So that's, again, another part of the frustration with that. If the kids are going to go to school in Battleground, I just assume they stay with their extracurriculars in Battleground. If the court is going to change that somehow and make that so that they go to the Ridgefield district or Southridge, whatever that school is called, then I would ask to maintain the existing order.
Ms. Gilmore?
Thank you. First, looking to school, I don't understand the basis of Mr. Zandy's objection relating to new evidence contained within our motion. Within our motion that we filed on July 9th, I attached exhibits presenting my client's position that Ridgefield, in fact, is the second best school in the district. And then the next page goes to Battleground, which shows that has an overall grade of B-. I then, in my reply, provided information contrary to the statements that, again, based on other self-serving statements, the Battleground is the better school district. My client properly provided notice of the relocation. There was an objection filed where she noted that she did not, in fact, have an objection to the move. The parties stipulated that the children would remain in Woodland for the remainder of the school year and agreed that we would need to address it in the summer. So my client has acted accordingly in the best interests of the kids. And I do think that silence on the part of mother relating to extracurricular activities really speaks volumes in this case. She doesn't deny the fact that she didn't take these kids to practices despite maligning my client's character and saying that he was abusing conflict. So
well, and Your Honor, that's what I'm going to object to. That's the stuff that all came in on the SIR reply. We have an answer for that, but we didn't get a chance to present it because it was on SIR reply.
Go ahead, Ms. Gilmore.
So we are asking again, Ridgefield is a better school district. It's close to my clients, just equally as close to. Mother has only lived in Battleground since the party separation, which has been a very short period of time. She is literally living in temporary housing above a gas station, Minimart, whatever you want to call it. This isn't permanent housing. So we are asking the court to lean towards the better school district. Again, it's 5 miles away from my client's home. Kids can ride the bus and they will be with their step siblings. As it relates to the child support, this is temporary orders. We don't need a substantial change. And at the time that we were before the court, mother had provided no K-1s, so no tax records relating to her business, and she provided no bank statements. She filed a motion for child support in August with one screenshot of her deposits of $1,500. It was 1 page long. The motion was subsequently set over 4 or 5 times based on the court ordering that both parties needed to provide more evidence. At the time that the court finally ruled in December, the court acknowledged that there wasn't enough information and imputed her at 30 hours at a minimum wage. Mr. Zandy makes the allegation that the court somehow contemplated these living costs already within the imputed amount, and that's factually not correct in this case. I'm not, within my client's pleadings, we're not arguing that gross receipts from the business should be attributed to her. I'm very familiar with the tax law and how businesses work. We are asking the court to put her at the K-1, which is her actual income. I'm not also asking the court to impute her based on her bank statements. I'm asking the court to allow for deviation given the almost $100,000 of funds that she has access to, which supports that she has more than ability to pay for the children's basic needs in this case. I think that, again, Mr. Zandy's argument relating to the $4,000 of attributable living costs, he intentionally confuses that. He's claiming that we're asking for the court to impute her $4,000 for these additional second jobs or what she's selling on the side. That's not what we're asking for. We're saying that she receives over $4,000 in housing benefits living in a 5-bedroom place in Battleground. This is a substantial benefit that she basically has no living costs that she will need to live. And this is identical to the situation where case law has made it clear that BAH should be included. Looking to, again, my client's rent, he's clear within his declaration. His mortgage is $1,950. He came to an agreement with a friend that he would be paying roughly the exact same $2,000. He testified in his declaration that he hadn't received rent for June, July. He hasn't received rent for August. This is an additional income. I frankly don't know why we need to parcel through my client's financial declarations, but I think it's important to note that he's living with a 7-people household, given he has 2 families that have merged. So these additional costs are reflective of his entire family unit. He's not suggesting that he's paying $300 for his own here. So given the fact that the new information we have based on discovery with the K-1 and the bank statements, we're asking the court to put mother at her actual income. We're asking the court to deviate based on her ability to pay for basic necessities under a 50-50 parenting plan. And we're asking the court to allow the children to be enrolled in Ridgefield. Again, they were alternating back and forth between the parties on sports, and frankly, based on the information that we have, they frankly were never actually ingratiated in battleground. So where we're looking truly is just brass tacks, where the children are better off and their best interest is in Ridgefield. Thank you.
So tell me the current ages of the children. I don't care, a parent can tell me. I just need to know.
Hi, Theo just turned 9 in June. Henry will be 7 in a few weeks, and Nora's 4.5.
Thank you. So let me ask this, and Mom, you can just tell me the grade. Tell me the grade of each of the children.
Nora was participating in a preschool daycare in Woodland. I don't know the status on that since he's moved out of Woodland. So she won't be starting kindergarten until the following year. Henry will be in 1st grade and Theo's going to be in 4th.
Ms. Gilmore, can you have your client or you, whatever, I just need to know what Nora's doing.
She's currently still enrolled in Woodland. I advise my client not to make any changes until we have an order, but and presumably she'll go to a similar program in Ridgefield.
We're going to keep her in Woodland for now.
Okay, it sounds like they were going to keep her in Woodland for now.
Okay. All right. All right, anything else from anyone?
No, I would just, if they're going to plan on keeping her in Woodland for now, that would require my client potentially going from Battleground, dropping the kids off at school in Ridgefield, dropping Nora off in Woodland back and doing the same thing. So it's more kind of the same concern.
With that comment, Your Honor, just to clarify, Nora is only going to that daycare during my client's time, and that's historical.
Okay. All right. So here's what I'm going to do. This is always a challenge. You have basically a shared schedule type idea. You've got 2 different schools. I am not going off of what I've been told as far as these schools, either direction. And I say that because I have nothing to substantiate, who came up with this, that they're the best, they're the worst. The court has nothing to say, yes. So we have no expertise other than some numbers in that. So that's not what the court is looking at. That said, the court also doesn't know what the plan is in regard to Mom, understanding she's living over the business and not sure what's going to happen there. So the reason I was asking about the ages is I couldn't quite recall how old they were. They are at young ages. So when we talk about things like, having their best friends or having connections to something, at these ages, is there some? Of course. At the same time, the court cannot look at children at these ages that they also tend to have more flexibility in where they're going, what they're doing. And it's not like a 14, 15, or 16-year-old that that's their whole life is who their friends are. So as it relates to that, to say, well, they should be in Bridgefield, or yes, they should be in Battleground. The court, again, is not looking at that as being the key as it may need to be. So with that, in looking at what the court sees as call it the most stable as it may be, at this point, the court is going to go ahead and place them in the Ridgefield school. In looking at it, at least in looking at the overall, the more settled future idea. That's not anything against Battleground. For the reasons that I said, the court's not going to look at one school being better or worse. It's simply that looking at in the long term that Ridgefield seems to be more of a stable plan as it relates to the children. The reason I was asking about the children had to do with the extracurricular activity. Again, looking and trying to figure out for their ages, how connected are these, or are they the young age types of activities? So the extracurricular activity, for all the reasons that the court talked about last year, they're going to remain the same. They're going to be split. Again, this is about if you have a 9-year-old or a 4-year-old or whatever it may be that is in an extracurricular activity at that particular age, that it's about who their best buddy is in that activity. It's not about where that activity is. So that extracurricular activity remains the same as the court ruled. That all said, the court, this is a temporary order, and it was on limited information that's been provided and looked at, and knowing these children, the court doesn't have a lot of information. Typically, I would have a guardian ad litem that might be involved, but I was looking, and it's Heather Call, and it looks like, I don't know when the last time she made an appearance on anything in this case, but I believe she's the one that's down in Clark County now working. So what I want to do is I want to appoint a guardian ad litem. Who are the next three?
The next three names are Beth Fellows, Sherry Evil, and Height.
Ms. Gilmore?
I'll strike Beth Fellows.
You're good with Beth Fellows? Is that what you said?
I'll strike her.
Oh, strike her. Okay. Mr. Zandy?
I'm good with any of the other two.
Okay. So we'll go with Sherry Evil for the guardian ad litem. Private pay, same percentage as child support. The purpose in what I'm looking at is the court does not look at either of these parents as being bad parents in the sense of the kinds of things that we may typically see or why we might have a guardian ad litem. But again, it's trying to figure out, are there any particular issues as it relates to these children that may have more effect on a decision like this than just an age or just this. So the court wants to have the guardian ad litem to really look at the overall connections of a child. Are there any issues regarding that child, whatever it may be. So just in general, what's in the best interest of the child. So the reason I am saying all that is the court, although the court has said Ridgefield, because of the stability, once the guardian ad litem comes into play, the court is not opposed. If there's a recommendation, the court has a good basis for changing it, the court would do it. The court doesn't like to do that. The court likes stability. That's the whole reason I'm going with Ridgefield for right now. But I just want it clear too that these are temporary, and but that's where I'm at with the guardian ad litem. I'm not looking at them investigating the issues of alcohol or drugs or any of those things. I'm not aware. If there are things, you can bring them up. But I do want the guardian ad litem involved. As to, so the extracurricular remains the same, child support. In regard to child support, in looking at all the issues that have brought up, and they were all the same issues this court has looked at before, are there issues and questions on both sides? Yes, there are. Are there some more pieces maybe on both sides? Yes, a little bit. But the court is not going to modify the child support as new little bits and pieces of information come in. So the court denies the modification of the child support as to the amounts. What the court will say is how much is being transferred from the father to the mother.
It's about $900 a month. Things like 906 maybe. I can look at that real quick. Yep, 906.
Okay. So as to that part of it in particular, I don't know if I was just why I didn't, but the one part that kind of stuck that I was looking at had to do with the amounts, total amounts of the accounts that the mother had. Can you remind me again, Mr. Zandy? She has the one account that she's had that dad's co-sign, not this.
Got 35,600 or something in it.
Okay.
And then the other one is the IQ account. That's got about 16,000. Again, those fluctuate.
Okay. So that's where the court has some, I guess, newfound issue or concern that there was no deviation at all. So that's where I don't know what it would end up being without a deviation. So the numbers are going to stay the same at this point, other than the deviation. I wanted to know if anybody has any idea what it would change to.
Well, I don't know if you can. I don't think the worksheets will allow you to do that. It's unless you say, I'm going to attribute, an extra $200 a month or something to mom's income, because now we're getting into, you can factor in like a 401k. There's a section for that. How much is, one parent contributing voluntarily to a 401k, and you can check that out. But as far as savings accounts, as far as the actual value of the 401k, there's no place to do that. It's the same thing for savings accounts. So I think the income based on the child support is statutory, because you can't necessarily count on digging into what would be a retirement or a savings or an IRA or something along those lines. So I think we're getting into big problems doing that.
Okay. All right. Ms. Gilmore?
I understand the court's ruling is that the incomes remain the same. Once I get back to my office, I'll confirm what the transfer amount is with a residential credit. If it's substantially different than 906, I can bring it back before the court on entry. Does that make sense?
Mm-hmm.
And then we need an order for so that the kids can be enrolled. Is it possible that I grab a bench order and send Mr. Zandy a picture of it, and we can get it entered, just saying,
I trust you. Just one sentence that says children shall be enrolled for 2025 school year at Ridgefield pending GAL review.
Sure. Okay, I can do that.
I'll do one better.
Okay.
I will fill out a bench order, and I'll just have a judicial assistant email it to the two of you.
Great, I appreciate it.
Okay. All right.
Fees, Judge, with anything?
As far as fees, no. I think there were issues that needed to get addressed, and with the move in particular, that there needed to be some things that were settled. So with that, no attorney's fees at this time. Mr. Zandy, I guess my only question, I'm showing a CIR. You're saying that I mean, we've had this brought up several times that attorney's fees cannot be requested in a CIR. So, but you said you said something else about you thought there could be here, and I didn't know that.
I would agree. You cannot issue spousal support. You cannot award attorney's fees if it's just based on a disparity of incomes on a committed intimate relationship. I think that's what the legislature tried to differentiate from a marriage. I think you can for the same things that we would in any other court. If it's something's not timely, if it's sanctionable, if there's terms for a CR 11 or frivolous filing or something that's already been considered or procedurally incorrect, I think you can issue fees in the same capacity you would in any other case, whether that's a parenting plan establishment or divorce. So I think that's the line of demarcation between the two.
Okay. Well, again, I don't find any wrongfulness in what was brought, except
Understood.
possibly in regard to the child support. So I'm going to just deny any request on that part. All right.
Very well. Thank you, Judge.
All right. Thank you.
Before we log off, do we want to set a presentation date?
She already logged off.
Okay, we'll work through that.